Good morning. We're on the record. Remember Decker throwing stuff around.
To this position.
Good morning. This is the time and place set for the regularly scheduled monthly meeting of the Taxicab Authority Board of the State of Nevada. It is Wednesday, December 17, 2025. The hour is 9:31. We're at the Nevada State Business Center, 330 West Sahara, Suite 400 in Reno, Nevada. Excuse me, Las Vegas, Nevada. And I will call us to order. The record should reflect that present are weekly Liz Decker and myself, Dan Reeser, Chair. Vice Chair Graff has an excused absence. He's tending to matters ordered by a court. So I will ask you all to stand and join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Having reviewed affidavits of posting and confirmation, affidavits of notice and compliance certifications of posting, it appears to me that this matter has been properly noticed, posted in accordance with the open meeting law. Take us to our first public comment session. This matter is set on our agenda for the purposes of hearing from the public matters which are in the jurisdiction of the board. We may not take action on those matters, but we certainly welcome any comments on things thereof or considering from the public. I'll open public comment to anyone present in Las Vegas in the hearing room. Is there anybody that would wish to make public comment other than the personal one? Seeing none, is there anybody online that would like to make comment? Okay, well, I'll close our first public comment session. That takes us to agenda item 3. These are the minutes of November 19th, 2025 regular meeting. Board members have had an opportunity to review them. Are there any changes, additions, or corrections?
Mr. Chair, if there are no changes or deletions or any comments, I'll make a motion to accept, please.
Is there a second? Been moved by Weekly, seconded by Decker.
Oh, no, I'm sorry. I'm abstaining. I wasn't there.
Oh, okay. You weren't.
Right. So I'll second.
Okay, seconded by Vasquez. All those all those in favor signify by saying aye.
Aye.
And Decker is staying. That takes us to agenda item 4, which is a regularly scheduled opportunity for members of the industry to bring forth matters that should be considering or of concern. And we happily listen to these matters, and I see we have somebody who would like to address this.
Gordon Balvin with Desert Cab Company. The risk of beating a dead horse, I wanted to mention again this, the illegal operators or the operators that might be legal that are operating illegally. I was at the rodeo was in town, and so they have the Cowboy Christmas, which is the convention, like gigantic swap meet at this entire South Hall. It's gigantic. So I was over there on Saturday, 2 Saturdays in a row. There are literally thousands of people coming and going into that place. It's in the middle of the daytime, right? So I went in there like 9:30 in the morning. When I came out at noon, 2 Saturdays in a row, there literally are the operators. They look like Uber and Lyft cars, but they have tablets, that say taxi service, and they're standing right there and they're soliciting people. You need a ride. You need a ride. That's not how Uber and Lyft work, and it's just blatantly happening. And I don't know what the answer is, but it's, the loop is taking rides with their ticket, these cars, but the other side is just a free for all of people soliciting. It's literally like if you've fly into Cabo or something, you walk out of the airport, how you're, everybody's running up to you, need a ride with the holding these things. And again, we know what's going on. It's the only thing that would be happening during the rodeo, during the daytime, would be this large convention where people are coming and going. And I don't know why we wouldn't have some presence there to at least run these people off. If we can't arrest them or do something to them, I mean, I think it's illegal. I mean, they're soliciting cash rides with signs and by voice. They're not just doing the sign, they're doing everything. And it's just, again, it's a free for all. So I just want to bring it to your attention that I don't know. So we need to do something. That's just, it's getting worse and worse and worse. And it's not going to stop until we have some kind of presence or do something about it, whether it's changing, through regulations, changing the laws, whether it's I don't know if it's a statute or a reg. I don't even know, because it just doesn't seem to be getting enforced, and no one's really told me why it can't get enforced that I can understand. Because if it was something that I understood, then we could hire lobbyists, people to try to change that so we could enforce it. So that's all. Thank you.
Any other public comment industry comment in the room? Anybody from the industry want to address us remotely? We'll close agenda item. That takes us to agenda item 5, which is the public hearing on pilot programs that are in place. This is regularly set on our agenda for reports on progress. We have one up and running, and to my knowledge, the other ones haven't turned on. Is that correct?
That's correct.
So is there just didn't want to solicit this if couldn't. Is there any action we need to take to advance any of these? I mean, we've given our approvals and.
No, I don't think so. I think they're all still working towards it, and Belvin.
Yeah. Go ahead, Mr. Bell.
Hi. Yeah, George Balvin with Desert Cab in Virgin Valley. Yeah, I just wanted to inform you, we are no closer than we were last time we were in front of you, but it's not on our side. This is on Uber's desk, and they're a gigantic company, obviously, and they have a pilot going with somebody already and through legal, and it's painfully slow dragging on their side. So I wish I had something to update you on, but we don't. Hopefully by next time we will, but at this point right now we're in the exact same place we were 30 days ago.
Well, not that it makes it any easier, but they were painfully slow when we did the very first one too. So.
I just wanted to update you.
No,
That's where we
appreciate to know where you're at.
Thank you.
Bailey.
Yes, sir. Michael Balin, Yellow Checker Star, UCAB 1, 2, 3, and 4. We're planning to test both captains, and we've already do have one curb integration in one of our cabs. It's only gone out a couple of shifts. We have a couple road supervisors. Looks very positive. They're getting 10, 12 rides a day off of Uber. They say as soon as the meter goes off, they're getting another hail. So, but it's very small scale. We don't have the back end to really run curb on a large scale at this point. So,
Okay, but you're at least up and operating.
on that one vehicle, yeah, and we're really surprised on how well it's working. Thank you.
Good morning, Curtis Mel, Deputy Administrator of Taxicab Authority. Just for clarification, and I may not have gotten it to Todd in time, Curb has started their program.
Oh,
But as Mr. Balin just spoke to, they just have one cab out there right now, but they did kick it off on the 4th of December.
and Are they, are they expecting that ELO will get additional vehicles?
I'm sure they're hoping that all their cabs become that way.
But I mean, is
There is more slated.
Uber, is Uber holding them to just one vehicle?
No,
Oh.
I think that's them. There was another company that had some, but they have turned. So it's a work in progress.
Okay.
As everything is.
And Desiree Dante, on behalf of Lucky Western and Nellis Cab, we too, with the curb technology, launched on December 4th. So our stats will be submitted next month to you as required.
Okay, so we'll see stats.
Yes.
I do. Oh, sorry.
Oh.
Not for you. Sorry.
George.
Bill George with WHC, Z-Trip. Just to give you a little update, we are continuing to go and we've worked through most of the technology issues now, which has been a long 90-day chore to get that going. So now we're really focusing on driver behaviors. So what we've done is started to use some employees where we're restricting them to solely doing Uber trips so we can maximize and see what the potential earnings are. We're posting that so our drivers can get on board and understand the program better. But just some quick stats. The average trips offered per day right now is 1,853 trips per day.
863.
1853.
Oh.
Now, the acceptance rate from the drivers ranges as low as 2% to as high as 37%. So we're still getting, when F1's in town and there's a surcharge, the drivers, even though they're charging, they prefer to stay in their proverbial lane with the regular cab business. But we're seeing, and I think we'll start to see some more as it slows down a little bit in the traditional lull here for the next 2 or 3 weeks, more trips there. Average fare is $20.70. And what I told you I would be excited to expand on last month, 54% of the trips are happening off the strip, only 46% on the strip. So that continues to go with what our goal was to see if we can't bring this out to the neighborhoods more and increase the area of service that cabs are going to be available. And then lastly, we had a preliminary meeting with the airport on Monday to just apprise them of this plan and to request further discussions as to how the best way would be for cabs to be able to, the customers that use the Uber app to select a cab, how that would work at the airport for pickup. And they're in the early stages of reallocating their curb space, so their timing is perfect, but that is going to be a multi-month set of meetings to get something done there. And then all of our information is in the monthly report that.
Yeah, Mr. George, would you say, based on the pilot, since you've been doing this the longest, that the program works?
It does now.
I don't mean the software. I mean the pilot overall.
Oh, yeah. We still have an occasional thing where a marked cab will go and pick up at the TNC area and somebody from the hotel didn't get the memo yet and questions it. We think we're actually just going to print flyers out in the car so the drivers can just hand it and say, this is approved by the TA and this is what we're supposed to do and signed by Uber. Little things like that. But all the bugs, the things, and now it's really just fine tuning and learning more and how we can optimize the system. And then it goes all back to driver education.
But in terms of the program overall, would you say it's good for the industry? It's good for the public?
Yeah, I mean,
Are there any downsides?
no, because there's been zero consumer complaints, number one. Number two, we have to make the assumption from the industry side, any trip that came to the taxi cabs as a result of the Uber app was a trip that was not going to go to a taxi cab to begin with. So it's net new for the taxi cab side of it. And third, it's providing more supply to make it easier for people to get around Las Vegas. So everybody wins on this. There's no downside.
So I'm a huge fan of this program. I remain concerned that we are authorizing pilots in contravention of the law, the AG's guidance, and I'm more concerned with making it a permanent option for the industry. And so I have a few questions for the agency based on the AG's previous guidance.
And recognizing that we've already set the end.
Right.
Okay.
Pilots end in April, but we know at this point it's successful. I don't think there's anybody that's going to say there are questions as to its value to the industry or the public at this point.
Were you here at the hearing where we talked about the fact that there's some hurdles to the permanent?
Yes,
Okay,
and that,
okay.
those are the questions I have.
Okay,
for the agency, based on the AG's guidance. So my concern is, what do we do in?
George need to sit in the
No,
hot
you
seat?
don't. In April,
Sorry, we have Ethan Revelos on the line that wants to speak also.
Okay.
Just to let you know.
Yeah, well, go ahead. Take that comment before, yes, it affects your thought process.
Mr. Revelos,
Hi,
can you,
hi, Cherry. Yeah, can you hear me?
Yes.
yes,
Hey, great. Yes, so I just wanted to speak to the point that, yes, Curb did start with Uber referrals December 4th. We're doing them at Lucky, Western, Nellis, the one car that Michael Balin mentioned at YCS. And we're actually doing 1 or 2 cars still at Deluxe Cab. And we're looking to expand it, but it's, as Michael Balin said, it's going quite well so far. And we look forward to presenting our report at the January meeting.
Thank you.
Thank you.
Okay, go ahead.
So based on the AG's guidance, in order for this to become a permanent option for industry, there are carrier contracts that need to be reviewed with the TNCs. There's a cost recovery audit that the agency was going to do to see if there's any cost recovery, because I think right now you're not getting anything from those rides. So theoretically, that's a net negative for the agency's revenue.
Well, we still get the same amount from those rights.
You do? Okay.
We do.
Okay.
And the airport gets their money.
Okay. There was a mention that there would need to be a rate case with the NTA for the TNCs for the rides brokered by them. Has that been started?
No.
I think we would have to do a rate case to approve a rate that's based on some NTA rate, approved rate. That was the
Okay.
nuance there. It was, they've approved,
Right. So we would have to
they've
incorporate.
approved something.
Right.
We would have to delve in and determine whether that is adequate for us. And if it's adequate for us, how do we approve a rate based on another agency's rate making?
Right.
Yeah.
Okay.
That's, I think, one of the more difficult.
Okay. And then the TA was going to identify taximeter requirements, compliance, and identify any deviations from the taximeter requirements.
Yeah, and all of the meters that are being used right now are NTEP certified, and that's what we base it on, is the NTEP certification.
Okay. Okay. And then just to check with the AG, does that mean those requirements are met? Somehow the law does not need to be changed, or is that still something that needs?
I still recommend going forward with changing the NACs.
So is that something the agency has started or anticipates starting before April? Or?
On the rulemaking, I agree. I agree with Steve that I think a rate case is not adequate here, that we need a regulation. And my initial view, and get told differently by the AG's office, is that our statutory authority is sufficient. We are in a making process with LCD right now. And we have gotten back just in the last few days a draft. They took our draft and did the magic LCD on it, and we're going through, Ms. Webb and I are going through and seeing what they did or didn't do. My initial thought is not to start a new rulemaking, but to use that rulemaking to reopen a workshop and tack on,
Right.
because elsewise we start, as you know, if you're in a rule making with LCD, it's easier to add than it is to start all over again.
Sure.
And so I think we had been waiting for 4 months, 5 months for any heartbeat out of LCD, and we finally got something.
Okay.
So,
All right. And the reason I ask is I'm concerned that April comes. Industry, I imagine, is concerned. No one's going to want to shut down this pilot program pending a gap in figuring out whether it's legal to continue. So we have a few months, and I'm just kind of looking forward. And just so industry knows, I think LCB once estimated that it costs about $100,000 to process a rule. And I understand we're having a rate case today. So I just want to make that public for industry that the rulemaking is not free and it costs the agency money. Okay, that's all the.
things.
No.
Any other comments on the pilot? Anything else, Administrator?
No, I'm good. Thank you, sir.
That'll conclude agenda item 5. That takes us to agenda item 6. Matter is on our agenda on the application of. Going to slaughter this ethical. I don't know if that's how they are announcing that, which is an application to acquire PPCT 884 sub 4. And first, before we hear the application, first item before us is there is an intervention. I don't know if the interveners council is here. Is intervener? Are you the interveners council? You are? Great. So before we get to substance, I think we should address the intervention petition. So there was an intervention petition, an answer opposing, and an intervention reply given yesterday. Correct, counsel? You want to make your appearance?
Yeah, Brian Hardy with the law firm of Marquis Arbach on behalf of the proposed interveners, the Chenoweth sisters, which are the some of the owners in the particular company.
And go ahead.
Good morning, Chairman, members of the board, Administrator Park. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the joint applicants this morning. Joining me also on behalf of the applicant buyer is Mr. George Balaban.
So I'm going to follow the practice of my very favorite federal judge in Los Angeles and say that my recommendation to the board is that we grant the petition for intervention, but that it be limited to the intervener addressing issues that are within our jurisdiction as to the adequacy of the application and not a attempt to advocate or litigate or create some kind of a record in front of us relative to corporate law. My reference to the federal judge is as follows. Ms. Rushton, I will give you 5 minutes to convince me I'm wrong in the presence of the other board members, and then they can weigh in.
Certainly. So again, for the record, Kimberly Maxon Rushton, as noted before you, there is a petition for leave to intervene. In the answer that was provided, I specifically stated the statutory, or excuse me, the regulatory authority that allows an intervener. In this instance, they have to demonstrate a direct and substantial interest in the application. The matter as presented in the intervener petition is specific to a district court matter that does not pertain to this application. In fact, as noted in the answer, there is no complaint about the information that was submitted. There are no inadequacies relative to the application, no infirmities relative to the suitability of the operations or financials of the applicant buyer. That is as far as this agency can go. Otherwise, as Nevada law has stated, a direct and substantial interest means that the petitioner demonstrates that they have a direct interest in the matter before this regulatory body that cannot otherwise be remedied but for their intervention in this proceeding. That's not the case here. You cannot grant relief, the relief that is sought by the interveners relative to the corporate matter that exists between the Chenoweth sisters. For that reason, I would respectfully submit that the answer substantiates the fact that this does not in any way advance the public interest. That is your standard as a regulatory body. Does the intervener action advance a public interest? Have they demonstrated a direct and substantial interest in the specifics of the application that if otherwise not allowed to participate, they would be detrimentally harmed? Those factors don't exist, and for that reason, the intervention should be denied. Thank you for your consideration.
Thank you, Ms. Rushton. Why is it not? Why have the interveners, respective interveners, not shown a direct and substantial interest on the point of whether or not the signatory to the purchase and sale agreement has legal authority to alienate the property, to actually enter the agreement that we have to approve?
Certainly. And I believe that that's addressed in the TRO specifically because Judge Denton allowed the applicant seller to move forward with the application. And it specifically states that the TRO does not preclude her from moving forward with this proceeding. So at this time, the application before you is a finding of suitability as to the Balaban's ability to acquire Nellis Cab and thereafter operate it in a way that is consistent with your statutes and your regulations. We understand, again, and Mr. Hardy and I are both very familiar with the ongoing actions, not only with respect to the district court, but with respect to the bankruptcy. By your approving or considering this application today and approving it, you are not transferring the certificate. First of all, you know that your approval does not automatically do that anyway. There is a compliance period in which the applicant must demonstrate other compliance standards that to the administrator's satisfaction before that actual certificate can be transferred. But in this instance, what we're seeking is approval because of the fast track that we're proceeding with under the Chapter 11 bankruptcy. There's a 120-day period in which to submit the plan of reorganization. If you approve or determine that the Balabans are suitable to operate Nellis Cab and that the application meets the statutory and regulatory criteria, then we can present that to the bankruptcy trustee and hopes that within 60 days, we're out of the bankruptcy proceeding. The application at that point, you'll have the authority pursuant to the trustee to formally transfer the certificate and Mr. Balaban can proceed. It also, what it does is that by proceeding with today's consideration of the application and then submission of the plan, it gives the bankruptcy trustee confidence of the fact that now going forward, that the manager member of Nellis Cab will have the ability to meet the financial obligations of the company, which is the point of a Chapter 11 reorganization. So specifically, those are the reasons I believe, Chair and members of the board, that you should proceed with the application and that it does not otherwise, the district court action precludes you from doing so.
So for the other board members who are not necessarily legally trained in playing inside baseball here, I think it's important for them to understand that in the state district court proceeding, there was a request, there was an injunction request. There's a request to enjoin us from action. And the district court judge wisely charted herself around that issue and said, no, I'm not enjoining state agency action. So that's important. The second is on December 5th, correct me, counsel, if I'm wrong, bankruptcy was filed, and it's a Chapter 11.
Yes, sir.
For one of the companies, and then the second company filed.
Pardon?
For one of the companies, and then the parent company subsequently filed, I think 2 days later.
2 days later.
Correct. I think there's two bankruptcies, both the parent company and the Nellis Cab.
Parent company that controls two cab companies, right? And one of the cab companies filed Chapter 11 also.
Both So the cab company and the controlling parent company have both filed bankruptcy. So Sun Cab and Nellis Cab have both at this point in time declared bankruptcy. And then in the underlying case, there was the injunction that was put into place by Judge Denton that prohibited the sale but allowed the application to proceed forward.
My suggestion to the board is but I'd like to hear from both counsel if they think this is wrong. Let's bifurcate the intervention from whether we have jurisdiction. Because there is a issue that intervener wants to raise as to whether we have authority under the automatic stay to take any action. That's a jurisdiction question. That's not a question of intervention in my view. So 1 minute, any response to
On the intervention specifically.
on the intervention?
With respect to the intervention specifically, my clients are an owner in this particular company. They have a vested interest in this particular sale because the proceeds of that sale would necessarily be distributed to them. And not to argue the underlying issues, but we're aware of other opportunities which may have created a better opportunity for them to receive that, which is why they have a vested interest in making sure that the sale to the person buying it for the most amount of money would then be the buyer. And that's why we have a vested interest in this particular issue. Thank you.
Any questions of counsel on the intervention?
Well, that would be up to the bankruptcy.
As to whether
The trust.
what the best deal is?
Right.
I concur.
Correct.
I think,
And that would be the jurisdiction of them, which goes back to our jurisdictional argument that'll be next.
but not whether the intervention is well taken,
Right.
whether there is a direct and substantial. So my recommendation was to grant the intervention because I get Ms. Rushton's, I get both arguments. I think it is a close case when the interveners own fined 50%, I think it is, of the entity that's going to be transferred. To say that they don't have some direct and substantial interest if we're transferring it, or we're going to allow not the contractual transfer, but the transfer of the critical asset. So that to me seems close to the heart that I will be quiet and let other board members.
Are you granting it, but not as to jurisdiction?
Well,
Are you recommending?
I think we have to go to the jurisdictional issue.
You do.
So it's just a matter of, does the intervener have a seat at the table when we talk about jurisdiction, or does the intervener not have a seat at the table when we talk about jurisdiction? Any
Regarding the 120-day window to file the reorganization, you a little more clarification?
I think that goes to the jurisdictional issue that we're not trying to decide. That will be the next issue we decide. But there is a window of 120 days where the debtor has to say, this is how I want to reorganize myself and submit that plan to the bankruptcy judge for approval. So I do think that is a relevant point when we talk about, do we exercise jurisdiction? Can we exercise jurisdiction? Should we exercise jurisdiction? But not whether or not the intervener gets a seat at the table. Does that make sense?
Yes, sure it does.
And
I think just based on what I've heard thus far, I get what the gentleman have presented to us. But just something that you said just kind of raises a question in my head that because the owner shares 50%, is that what you said?
there's two daughters that combined own 50%.
And so because it sounds to me like, and maybe I'm wrong, y'all correct me on this, that she's waiting to see if she has that authority to be at the table. But on this end here with Ms. Rushton, I agree to a certain extent that I think he used, was there enough advanced public interest in what she's asking for? And if it doesn't align with what the current law says, then why are we considering a seat at the table if they're trying to get ready, because I'm of the opinion if you stay ready, you don't have to get ready.
I think that's where this is on close on the line.
And Chair, if I could, what I would point out to the board is, and again, it was specifically stated in the answer, is that pursuant to your statutory authority, the Nevada legislature has said you are the only body that can issue a certificate of public convenience and necessity to operate taxi cabs in Clark County. We understand the bankruptcy proceedings. We understand the specifics of the TRO. What we're asking is that you find the applicant suitable to obtain the certificate of authority and the vehicles, the assets of Nellis Cab. And prior to today, I provided in the application and then just immediately before the hearing, the corporate structure for Pete Glow and the Balabans. And that's important to this discussion because Nellis Cab is similarly situated. It's a Nevada Series LLC. So Sun Cab is up here and Nellis Cab is here. And there is statutory authority and there is case law that specifically states that when you have a series LLC and one aspect or is up, I guess, to be sued or the possibility of suing and everything, it's only that specific series LLC. My position is that you're considering the assets of Nellis Cab. The complaint involves Sun Cab and whether or not there are fiduciary duties at that parent level. That is not within your jurisdiction. We certainly recognize the fact that that is clearly within the district courts. But it does not offend the district court TRO, nor does it offend the Chapter 11 bankruptcy proceeding for you to approve this so that then Nellis Cab can go back to the bankruptcy trustee with the plan that says that the TA has found this individual to be suitable. Therefore, trustee, if you approve the sale, if the offer and the bid, the certificate and the assets is acceptable to you, then we may proceed. And I would respectfully submit that's in the public interest. One, because the company maintains its operations and it maintains the employment of all these individuals immediately before the holidays, and it takes care of its financial debts. And that's the objective of a Chapter 11. And it cures, again, what the original intent was. And that is that the company was interested in selling because of the fact that it was financially and looking at hardships that it couldn't otherwise afford. You have a certificated carrier who has a long history of suitability, both financially and operationally. And therefore, there is no reason or impediment legally that you cannot proceed with the approval of the application, which will again allow us to proceed with the trustee, with the bankruptcy.
But that actually goes to jurisdiction question,
Right.
not to whether or not the interveners get a seat at the table. We can talk about that jurisdictional issue next, but I think the first issue is, are we going to have an intervener in this matter? I do think the intervener should be limited. The intervention should be limited to only those issues, which I think will be a heavy burden for them to raise, that the application is somehow deficient or that Mr. Balaban and his company are not fit, willing, and able to have the transfer. I think that's, so to the extent the intervener wants to fight some other fight, I'm not interested. But if he knows that Mr. Balaban somehow yesterday became not fit, willing, and able, I'm happy to hear that. But that's why I'm saying very limited intervention.
And if I can just, we're here on jurisdiction, really on a bigger issue. I am not here to necessarily contend that Mr. Balaban is unfit for this particular issue. It's the issue here is jurisdiction and timing and the ability of this particular body to perform the functions and when it can perform those functions and whether there is a need and necessity for it to perform those functions at this time. That's where we're limited. And I agree, we're doing this on a very limited, we filed this on a very limited basis. That's the issues we addressed in this particular issue.
So you'd be willing to have your intervention limited to arguing jurisdiction, and if you lose on that, you're gone.
If we lose on that and you decide that Mr. Balaban is a suitable, because as I understand this, and I want to make sure I'm abundantly clear, because assuming you have that authority and that the bankruptcy state doesn't apply to you, of course, I reserve on that particular argument. But that Mr. Balaban is a suitable candidate to own a cab company. I think we can all agree he owns cab companies now and is likely a suitable candidate to do that. The real question at this is whether this particular authority to be able to find him suitable for this particular transaction has been stayed by the bankruptcy proceeding.
Well, let's not get into jurisdiction.
And even prior to that, whether that it would be prudent for this body to act before, and this is before predated the bankruptcy stay, because you got to remember we filed our original petition before the bankruptcy.
Counsel, not to interrupt you, but just yes or no, you would agree your intervention can be limited to arguing the jurisdictional issue.
Jurisdiction and proceeding forward timing wise, yes.
Well, I have a jurisdictional question. First, you
Well,
wanna
I
start?
think that you,
I'm not
we
saying-
can't decide intervention without knowing.
Distortion, I'm not saying.
Huh?
Without knowing what?
You need the.
No, but I have a question for Ms. Rushton on her argument
Okay.
regarding jurisdiction. If not Sun, which entity of Nellis Cab in its series are we assessing?
Nellis Cab is the container that holds the certificate of authority. So in the series LLC, Member Decker, what happens is that you have the container entity and then all of the series fall under that. So each of the assets that are held by Nellis are within these respective series LLCs. So the container, one that has the Nellis certificate of authority issued by the TA is the one that's before you for consideration. Not so.
So on the intervention, is there any further questions or discussion? Not, I will entertain a motion.
I will second your motion or your recommendation.
You will make a motion to accept my recommendation.
Yes.
Is there a second?
Second.
So it's been moved and seconded by Decker and Escas to grant the intervention. The intervention, you both, the mover and the second, agree limited to jurisdiction, arguing on the jurisdictional issue. As we move forward on the application, the intervener's not going to be here to try to prove to us that the investigation says he's not. So, is that correct, Council? Correct. You okay with that
Yes.
limitation? Okay with it? Okay. Any further discussion? All those in favor signify by saying aye. Intervention is granted on that limited basis. So I think that we need to flesh out the jurisdictional issue. Not trying to belabor this, but I think that's formally what we need to determine. So then that decides what we're going to do or not do today. So intervener, when you tell us why we don't have jurisdiction, and Ms. Rushton, you tell us why we have jurisdiction.
As set forth in our reply, we note that there has been a bankruptcy filed both by the parent company and the company at bar, which is Nellis Cab, right? So there's no question that the company at bar, Nellis Cab, has filed bankruptcy. In doing so, under federal law, there is a stay that incorporates at that point in time. It's an automatic stay on all proceedings with respect to anything that's going on with respect to the assets of the company. And that's done for a multitude of purposes, is to protect those people that are creditors and otherwise involved, but stops everything so that the court that has time, as we discussed, the 120 days, for them to be able to assess what's going on, identify the best potential buyers, anybody else that may be along, and see what they can do in order to dispose of the assets to pay the creditors in order to reorganize as may be directed. In this particular matter, we're saying that if they're asking you to approve the sale to Mr. Balaban, you are effectively violating that particular sale. If it's simply to say that Mr. Balaban is suitable, a suitable buyer, but you're not necessarily saying that he's the suitable buyer, I would question whether you even at this point in time, given the stay, have that authority, but that may be the furthest that this authority would be able to go, is to say, because then it's not affecting an asset, right, of the bankruptcy estate. It's simply looking at a potential buyer to say, you are one, you may not be the only one, but you may be one potential buyer. But we're not saying you're the buyer, because we can't affect how this asset is disposed of while there's a stay, mandatory stay, federal law superseding state law in this particular issue, on any proceedings that would affect the transfer of an asset. And so that's what I'm trying to make sure that we're doing here today, that we're abundantly clear on any decision that is made is it's that Mr. Balaban may be one suitable buyer, but he is not the suitable buyer. And that any other buyer that comes before you, subject to the trustee reviewing everything and determining that there may be other buyers out there. And we contest that there are potentially other buyers out there as a part of the underlying district court case. That there are other buyers out there that may be suitable, you don't know yet, and that they can submit an application if approved by the trustee. And going forward, we would approve or look at that particular application independent of this application. But if it's looking today for the transfer of the asset, that particular thing is outside of the jurisdiction and would in fact violate the stay as set forth under the cases that we've cited in there, including the recent advance decision out of the U.S. Bank case. And I think it was the U.S. Bank case was the most recent case out of the state of Nevada. So we would rest on those matters, and I'm happy to answer any questions that you would have.
Thank you. I'd like to start by stating that the application before you, as proposed, meets the specific statutory and regulatory criteria. And I think it's important that we go through that just briefly because of the fact that that is what you're considering today. Specifically, it's got what I would say somewhat of a complicated corporate structure, but this is not one that is foreign to this body. Obviously, as you know, we've argued before, Nellis Cab is a series LLC. The other two entities is owned by the Balabans are also series LLCs. That's done, as we've talked about before, for both tax and liability purposes. It's recognized in the state of Nevada pursuant to NRS Chapter 86. So when you look at that, you look at the background of the Balaban family and the fact that they've operated taxis since the mid 70s, close to when Nellis Cab was formed, which was 1966, you see that there's no ambiguity or question relative, again, to the operational suitability, the background of the individuals, and or their financials. One, because of the fact that you have access to their annual reports, which demonstrate the fact that both Desert Cab and Virgin Valley have consistently maintained the 20% equity. In addition to that, you also have the proposed financials relative to this buy that demonstrates, again, suitability financially of the Balabans to acquire Nellis Cab and then move forward with 6 months of operation that are compensable and meets the 20% standard. So with that in mind, I would respectfully submit that the application before you is ripe for consideration and meets all the regulatory and statutory criteria. We, as I stated before, recognize the bankruptcy proceeding. We are not asking you to transfer the asset. We're asking this body to approve the application and a finding of suitability for Peak Glow, the entity as proposed, to acquire Nellis. And then thereafter, if that is your ruling, we will present that to the trustee. As Mr. Hardy indicated, there could be other bidders in there. What we respectfully submit is the fact that based on the nature of this proceeding and our familiarity with the bankruptcy standards, that if we submit this, if you approve it and we submit it within the next 60 days, it'll move forward and that will be the conclusion of this. But I think it's really important, again, to note the fact that the bankruptcy was filed by Nellis Cab. Sun Cab is the entity relative to the district court matter. The last thing I would also note is, again, there's ample Nevada law as well as federal law that privilege license is not an asset. So what is not an asset? It is not a tangible asset. So when we talk about the value and things like that, it's because of the fact that it's based on all of the vehicles and the other tangible assets. What we're asking is that you approve the application, approve the ability of the trustee to grant Peak Glow the ability to operate Nellis Cab if that is approved by the bankruptcy court. When that occurs, then we'll come back to Administrator Park, demonstrate the fact that they've been approved by the bankruptcy trustee, and then proceed with the compliance standards. That can't be done while the matter's still before the trustee. We cannot proceed with the compliance matters simply because of the fact that, one, there is a stay relative to the movement of the assets, but also because of the fact it doesn't do Peak Glow any good to proceed with the compliance and the expectation of taking over Nellis until that bankruptcy trustee makes the final decision. So therein gives the the TA, the coverage that you need to proceed with this matter. Not, the assets will not be transferred. The application will not be finalized in the sense of the compliance until the bankruptcy trustee approves the proposed plan. With that, we would respectfully submit that the application meets the standards, that it should be approved, and that will then allow us again to proceed with the plan as we propose.
Ms. Rushton, you'd agree that in addition to the typical compliance items that have to be satisfied with the administrator, that we would have jurisdiction to add additional compliance
Yes, sir.
items?
It's
Given
contingent.
the
We
facts.
recognize this. Under Nevada law, this body has the ability to limit or condition any license that it grants. We recognize the fact that this is going to be conditioned on that.
So again, a bit of inside baseball, and I'm going to give council an opportunity to direct debate with me on this. I respectfully disagree, council, with 362 of the bankruptcy code. Provides that we have lost jurisdiction. I think there is a very long-standing case law that an exception to that 362, an exception under 362 is that the automatic stay does not extinguish our police powers. And this is a police power matter. Notably for the other board members, this issue has arisen in banking, insurance, and gaming, and litigated pretty extensively. Two of the most famous cases are Jaffe and Elsinore. And the distinction is if Nellis Cab was found by the administrator to be not inspecting its cars and putting vehicles into the field recklessly or in violation of law, he could bring an action to suspend the license, and we would have jurisdiction to do it. Even though that might interfere with the asset that is in bankruptcy. On the flip side, if Administrator Park said, hey, you know, Nellis is not remitting to us the taxes that are due. The Elsinore case stands for the proposition that we can't proceed to collect those taxes. That's a financial matter within jurisdiction of bankruptcy court. So I encourage the board not to that we not take any action on the jurisdictional issue that suggests that we view the bankruptcy automatic stay as having somehow ousted us from performing our regulatory duties and in the exercise of police powers. And I believe that the police power, this is my view, and happy to let council weigh on this, extends to whether or not a privileged license can be transferred or can't be transferred and to whom it can be transferred. There's also a fairly well-cited law review article done by my former law partner and bankruptcy judge, Greg Zive, where he explained that in this context, the bankruptcy court and the regulatory agency have to work together to get a job done, because the bankruptcy court does not have the power to transfer a license or to allow somebody to take medallions. That is a authority of the agency. And so to my thinking, we could move forward to find that Mr. Balaban's company had a glow.
Peak Glow. Peak Glow.
Pete. Okay.
Pete Balaban and Gloria Balaban.
Oh, okay. Okay.
Just trying to find.
Okay.
You know.
Peaklow is a suitable acquirer. It's fit, willing, and able to acquire Nellis. That the applicant's Balabans are suitable. And that if the bankruptcy court wants to allow a transfer to them, it may. If it doesn't want to allow a transfer to Fedglue, that somebody else will have to come back in front of us to get that approved. Now, I think also an option that the board has, and council can address this, is to take the easy way out, which the Gaming Commission has done on a couple of occasions, which is to say, we'll wait till we see the plan. When you bring us a plan, we'll approve whoever's in the plan. So that's a way, but I think we should be clear that we're not ceding our jurisdiction here in any way, shape, or form, because I think that's bad precedent for us down the road. But those are my thoughts. Council,
Well,
each.
hang on. Okay, before you move back to council, I'd like to weigh in. So my understanding of the case law that you cited is that as it pertains to enforcement action, we still have jurisdiction.
Mhm.
I do not know if that extends to an action taken related to ownership of a company. Either way, whether case law supports that or not, I agree with Mr. Hardy in that I have no desire to trample on a pending bankruptcy case, whether we can or not. There's no reason for us to do it, and I don't want to do it. So as far as enforcement action goes, I agree. Administrator Park can continue to treat Nellis as it does any other licensee. But when it comes to the board's action related to ownership, my inclination is to wait and not impact the bankruptcy court. I agree with Mr. Hardy in that the petition is not extensively clear as to whether we're deeming Mr. Balaban as suitable to be a potential buyer, or if it's to literally approve the sale. And so I think that there's a sea of difference between those two things. And the application says to acquire the CPCN. So I think it would be in our best interest and everybody's best interest to decide whether or not we're going to approve the sale of the CPCN as requested in the application, or as Mr. Hardy said, determine that as a potential buyer, Mr. Balaban is suitable for the bankruptcy court to weigh in assessing what they're going to do with the Chapter 11. And I think those two things need to be very clear as to which one we're going to.
So, Member Decker, I don't disagree with you, but the issue right in front of us right now is, do we or don't we have jurisdiction? My view is we should find we do have jurisdiction. Whether we exercise that jurisdiction is the third question. 3 questions: intervention, jurisdiction, action on the application. I may well hardly agree with you on action on the application. What I'm saying is, I don't think we should say we don't have jurisdiction.
Right. Okay.
Because that is a slippery slope. Where does the jurisdiction end? Where does it begin? I don't want to go down that. I don't think we need to go down that road today.
Well, I don't think we have to unless we're trying to make a hypothetical principal point.
Right. No, we just need to say we have jurisdiction.
Sure.
Is allowing the intervention to ratify the bankruptcy plan? Like the ability of Nellis County to
No,
organize?
the intervention that we granted has no effect on the bankruptcy plan. Unless council want to disagree. Okay, so as to, is there anything else anybody wants to say before we let council weigh in?
Yeah, we're good.
Okay, so you can weigh in on the Decker resurvey.
Yeah, Chairman Member Decker, I think you've hit it directly on the head as to, and I'm not going to dispute the fact that this body has jurisdiction over limited issues. And I think the case law supports exactly what the chair has said on that particular deal. It supports the police power. And that police power allows you to do enforcement and citations and all kinds of things to make sure to protect the traveling public and the industry, right? That's your job. And that cannot be superseded by federal law. It is going to happen at your level, okay? That is not what I'm asking here today. What I'm asking is to say, look, to the effect that you are going to be approving the sale of an asset that is currently subject to a bankruptcy stay, that is something that is outside the jurisdiction. And I think is consistent with the fact that even if you wanted to go collect taxes against them, you couldn't do it, right? You can't transfer an asset in a bankrupt estate. You can't do it. And so if the application is now just simply to say, hey, all we want to know is, are we good enough or not? Are we suitable or not to be a potential buyer? That may be something you have within your jurisdiction because that's the police power as to whether or not somebody is or is not a suitable. I would submit that he, as an owner of a cab company, you've probably already found him suitable as a general cab owner, right? But in this particular transaction, which you're going to be looking at specifically, that you have 120 days before anything's ever going to happen in this thing. And there's no urgency for you to do it today and to step on top of that, but to let the bankruptcy court. And one of the reasons that gaming has done it in the past, as you've seen, is they say, look, why waste our resources? Why waste all of our time? Why do all of this right now when we don't know who the bankruptcy court's going to approve as the ultimate buyer? Let them approve it and then make them come back to us. So we're going to say we have jurisdiction to decide the license, which you do, and you retain that jurisdiction. But that what you're going to do is wait until the bankruptcy court says, this is the deal we want to see. Can you guys go back and apply? At that point in time, that individual, whether it's Mr. Balaban or another buyer, comes here and says, would you approve my application? And then you can look at that application and decide thumbs up or thumbs down. And if it's a thumbs down, then it goes back to the bankruptcy court and they go to the next person in the bidding line, right? And that's the process that I'm encouraging you to do at this point in time. There's no need for this thing to happen today. There's no need to give some type of stamp of approval or anything else. But the jurisdiction that you have is police, and I would encourage you to continue police. That's good for the industry. It's good for the traveling public. But what you don't need to do is act on this today. And so he may be a suitable candidate, but we don't know whether he's even the candidate yet. And you'll know that in potentially 120 days or upon the direction from the bankruptcy trustee. Thank you.
Thank you, Chair. I think it's important to note that on each of the compliance orders that this body issues, it specifically states that until all of the compliance standards, conditions, limitations are met, that the certificate cannot be transferred and the authority does not vest with the applicant. That's an important factor because that's where you are today. If you approve the application, again, it does not interfere. It does not in any way step on the toes of the bankruptcy trustee. All we're saying is that within that 120-day plans, that's the plan that, or the time period that the bankruptcy court gives to the debtor. We would like to submit this week. If you approve the suitability, we can move forward with that. And again, hope to expedite the finalization of the Chapter 11 bankruptcy. If the trustee determines that there is another buyer out there, it doesn't change anything that you've done today. If you approve this today, you find him suitable, the trustee says, nope, there's a better buyer. The trust has the ultimate authority. So your approval doesn't change that. Then that person, yes, has to come back, exercise the review.
Yeah, Kimberly's talking right now.
Whoever's online, can you mute yourself, please? Did you finish?
I would just note the fact that, again, it doesn't in any way interfere with the bankruptcy proceeding. All it does is demonstrate the fact that you have done the work, you have done the investigation, and that you have determined that he is suitable. It does give him a leg up. That's the honest truth. So it gives us the ability to go into the bankruptcy court sooner than later and get this matter resolved, get the debtors paid, and ensure that those drivers, those mechanics, and all those individuals still have jobs during the Christmas holiday. So we would respectfully ask that you approve the application, condition it specific to the trustee's approval. If Mr. Balaban and Piccolo is not found to be the highest bidder, we recognize the fact that the highest bidder will have to come back before you to seek the same approval.
Maybe best bidder.
Best bidders. Yes, sir.
To address your compliance order, sorry, the issue that she's raised with respect to the compliance order.
Will you take his last swing before
Sure,
your question?
sure.
Take your last swings.
Thank you. I'm going to keep it limited to that, just the compliance order. What she's talked about here is that the compliance order, and we all know that a compliance order comes out, but what becomes inherent in the compliance order is that there's this statement that says, hey, when you take over the company, these are the things you need to do in order to be able to have issuance on that license. There's that presumption that there's going to be a transfer. And I'm saying you can't presume to transfer an asset of the bankruptcy estate. What I'm saying is you can't do that until we have an approved buyer. Let's not put cart before horse in this particular matter. Thank you.
So I have no problem with Mr. Balaban's suitability. I'm not sure that's what the application is for, though. So if we're changing the application midstream, then maybe we need to discuss that in a second. But before we get there, Ms. Rushton, is your position that if there were 3 other people at the table, that the board could approve all 4 and then kind of made the best man win?
You mean if 3 other applicants had submitted the application
Sure.
for consideration? No, because of the fact that that would not be the procedural course for this body. This body accepts an application. If you had competing applications at that point, then it would come back to the board to say, why do we have competing applications? Is there an issue relative to the ability to sell and to whether or not the value is compensable? Is this a true corporate sale or is it a straw man? Those are the factors that you would look at, Member Decker, relative to determining why you would have competing applications. You don't have that here. You just have one individual because of the fact that after the district court suit was filed in October of 2015, the decision was made by the sole member to move forward with the sale. Based on the TRO, then you have the bankruptcy proceeding. All of these things are done, Member Decker, in order to maintain the operations. But yes, the Nellis Cab and its sole member and majority owner has said that they believe that this is the best bid that they received or offer and that this is what is suitable for them. If it's not, the bankruptcy trustee will tell you that. But at this time, the sale and transfer application, the way that it's structured, Member Decker, is the fact that it approves Mr. Balaban to assume the transfer of the certificate. So it allows Nellis Cab to sell it, and it allows the transfer to take place. So it's really, an old antiquated term and everything, but the reality is that you can't sell a privileged license. The law just doesn't allow for it. So that's why you have the transfer aspect. So if you find that the application before you demonstrates that the PICO has met all of the specific statutory and regulatory requirements, then you can say, we find that the application meets those statutory requirements and that the Balabans and PICO is suitable to acquire Nellis Cab if approved by the bankruptcy trustee.
Because the question is, would a ruling allow the sale or would it direct the sale? Because it's,
Well, my interpretation is that it allows the sale. It says it has met the statutory and regulatory criteria that we have jurisdiction over to allow the transfer of the certificate and the medallions.
so we could approve 4 applicants and say,
No,
this allows any 4 of you to compete in the
I'm
marketplace.
going to say I disagree. That hypothetical is totally hypothetical for the following reasons. We wouldn't approve an application where there is not a binding, effective agreement to acquire.
Right.
There would have to, and there's a question in my mind about whether there's a problem with the agreement. We'll get into that. Maybe more than one problem. But I see one problem on the agreement needs to get cleaned up, but we're not to that point. We're at the point of, do we have jurisdiction? And my recommendation is that we, without saying more, we have jurisdiction. Then we move on to deciding what we're going to do.
Okay,
Sure.
do that.
Can I address that one issue if I may, Your Honor?
The one issue of,
The one issue of a binding document here, because you have the 90-day, everything that happened 90 days prior to a bankruptcy is unwound. In other words,
that's one.
is there a question whether this is and so can you act on an agreement that may or may not ever come to fruition? It's unwound until it's now finally and fully approved by a trustee. That's the problem we have here. And so do you have jurisdiction? And this is why my member Decker, I think, does have the appropriate, if my clients came before and said, we're going to go ahead and buy the remaining 50% interest out, and we want to be the full owners on this thing, and I submit an application, then they're going to say, look, you can't submit a competing application. There's already one in. And so, we want to be a bidder too. And so are you putting your finger on the scales of bidders right now by making a decision rather than just saying, hey, the next bidder who comes before us appropriately and has a binding agreement, that is an agreement with the estate as it has authority through its trustee right now, then that particular person, we can accept that application. So this application isn't appropriate at the time. We don't have jurisdiction over it.
But Mr. Hardy, I don't know that that goes to jurisdiction. That goes to whether there's a defect in the application.
I think it goes, if there's no agreement, then you guys have then this body has the ability to say jurisdictionally, there is no agreement at this point in time. We don't have anything that we can act on.
We had this debate a couple of weeks ago about whether something's jurisdictional or whether it fails to state a claim on which relief may be granted. Okay. And so I'm just going to say I'm pretty firmly of the view that what you raised is whether in civil litigation standpoint, we got a 12B problem, not whether or not we have jurisdiction. Because the court has, it's like a court has jurisdiction to decide whether it has jurisdiction. We have the power to decide whether we have jurisdiction. Then we decide whether there's some problem with the application that we're not prepared to take action on.
Fair enough.
Anything else, any other edification board members need on this point?
Chair Reader, I think it's extremely important to note for the board the fact that the underlying complaint specifically is between the Chenoweth sisters and SunCab and whether or not Michelle provided access to the corporate books and records. That's what we're talking about. This isn't an issue relative to the ownership. It's whether or not she provided access to the corporate records and she adhered to her fiduciary duties. It's not an issue relative to the ownership. So I understand, again, that it all trickles down and everything, but again, the action is specific to SunCab, which is over here. The bankruptcy proceeding is Nellis Cab. The matter before you is Nellis Cab. That is an independent container within the series. I believe specifically, again, you can move forward and it doesn't interfere or preclude the trustee from making a decision that is inconsistent with what you've made in terms of whether or not Peak Glow is the actual buyer or the entity allowed to acquire Nellis.
Sure.
One last shot and then that's it.
Absolutely. We appreciate it. Because I'm heavily involved in.
Horse is bloody and.
All right. Just because I'm involved in the underlying action, I want to make it abundantly clear. What Judge Denton found was that the asset of SunCab was Nellis, which is why he said, I'm not allowing the sale to go forward until we have a hearing to determine whether there was gross mismanagement on the part of the individuals. And so did he retain jurisdiction over that sale? He absolutely did. And so, and then not only that, then they knew that, which is when they filed both bankruptcy for Sun and Nellis in order to stop what was going to happen in the evidentiary hearing. Thank you.
Entertain motion on, do we have jurisdiction?
I will move that we have jurisdiction. However, we also have constructive knowledge of a bankruptcy that I do not want to completely ignore.
I think that's the next issue.
Oh, okay.
So there's a motion that we have jurisdiction. Is there a second? Second. Any further discussion? All those in favor signify by saying aye.
Aye.
Now we get to the point of whether there are, whether we want to process the application today or her, and how, if we're going to process the application. Proceed. We've all received confidential information that indicates that the individual applicants are fit, willing, and able, suitable. We've received confidential information that the acquiring entity is controlled by those people and that they also certificate holders. So that's the state of the record before us. I'm going to ask a couple questions, we already kind of touched on them. I'm troubled with the contract of sale, purchase and sale agreement has at least two that I recognize. The first, and so if there's others, I'd like to know that. The first one that jumped out at me is the same one Mr. Hardy pointed out. This contract is dated within the 90 days preceding the filing of the bankruptcy. We don't have jurisdiction to determine, that's a bankruptcy court decision as to whether that agreement is not enforceable because it was an attempt to dispose of an asset of the estate within, I forget the name of the period, but the what I call the lockdown period preceding the bankruptcy. The other one that could be curable, that I didn't read anything that made it curable, is that the agreement by its terms has an outside closing date of November 1st. And it says the agreement, absent a new agreement, is gone. It's not in, the outside closing date is passed and there wasn't a closing by November 1st. And so, you know, being somebody who writes outside closing dates and agreements all the time, I know what that means. It's the end of the hunt. You didn't close in time. Now it could have been cured, but I don't see a document curing it. So I'm going to let Ms. Rushton address the first issue, and then Mr. Hardy can address whether I'm right or wrong, and then you can each hit for tat over that one.
Yes, sir. With respect to the asset purchase agreement, the majority of asset purchase agreements that are before this body, as well as the NTA and gaming, all have the language that specifically states that the transfer is not completed until approved by the regulatory body. So the closing of November 1st was when the parties agreed that they would have all of the information ready and prepared to submit to the TA. There, you cannot do the transfer relative to the payment of the actual acquisition of the assets until you approve that. We understand, Chair Reeser, in gaming that you cannot transfer any amount. There's a little bit of a leeway relative to the NTA and TA. The general standard is that you could do an earnest money deposit of 15%, but anything over that would be perceived by this body as being an illegal sale and transfer. So you can't transfer the money until you approve it. And that's always a term of the compliance program. And we've asked for it to be made a term of the compliance for both the NTA and the TA so that the applicant seller doesn't have to chase the money, end up in court, having a court make the decision that's your decision. So again, all of these factors are specific to administrative agencies in how you oversee licensees and how you construe documents. But the closing could not take place, Chair Reeser and members of the board, because of the fact that you cannot transfer the money until this has been approved.
Ms. Rushton, you missed my point. So it is very typical with regard to license entity transfers to have an outside closing date, which says we've built into this agreement. I'm going to use gaming because that's probably the one that everybody's least counsel most familiar with. Typically, you build in a 12-month period because that's the speed with which the Gaming Control Board and the Commission operate. And it says if you don't close within that 12-month period, all bets are off. So you better get your approval within that period and satisfy any compliance conditions within that period, because elsewise the exclusivity under this agreement is going to go to somebody else. I'm going to sell this casino or this bank or this taxi company to somebody else. If you can't get the regulatory approvals, your outside closing date was November 1st. And I mean, unless I'm misinterpreting what you meant by that in the contract, it's just a simple outside closing date. Now, we don't need to belabor this because you could fix that tomorrow
And I would
with
suspect it was
a letter. With a letter agreement. You could fix that. But the question is whether your counterparty who's not in front of us believes that you can enforce that agreement. I don't know that. I don't know if they think, oh, Mr. Balaban didn't close by November 1st. That was the outside closing date. He didn't get his ducks in a row, and so I don't have an obligation to sell. So I'm concerned that on that point, we may have a problem. I'm also more concerned about the 90-day lockdown period.
And if I may, your chair, so I think you've made it an adept point, and not only that, but if you want to, and we all practice in the privileged area, and so we're familiar. If you want to have an open-ended without a closing date, oftentimes that happens where it says within 10 days following approval or 30 days following approval, then you can have a closing.
That's the smart money.
And that's the way that you keep these things open. That's what that is customary in the industry, as you're well aware. That didn't happen in this case. And so now who they have to go back to they're not going to go back to an individual. They've got to go back to a bankruptcy trustee who's then got to go to a court who's got to do it. That's 120 days out before we're going to get approved as to whether he's going to extend this one or not, or there's other bidders. Again, the cure, if they were to cure that at all, is something that's got to be done through the bankruptcy process now. It's not as easy as you would propose to simply go back to the person who originally signed the agreement, because that person no longer has authority over this company once they subjected themselves to the bankruptcy rules. And so I would propose that this is an uncurable, at this point in time, defect, in addition to the 90 days that I think we've discussed previously.
Correct, there's not. Sure, you're in agreement. The applicability of the 90 days to a transaction is jurisdictional bankruptcy court, right?
It absolutely is.
Right.
And it's for a purpose, is to make sure that nobody tries to transfer assets immediately before a bankruptcy for the preference of anyone else.
And it's not a hard and fast rule. There's case law on both sides. Yeah, the 90 days applies, another 90 days doesn't. But we just don't, that's not in our purview. Just like deciding patent system. Those are this Russian. What is your position on the 90 days? Let's set aside the outside closing date, which, that may be way too much inside baseball. But as to the 90 days, how do we resolve that today?
So the matter you have before you, again, all the APA does, you don't sit here and determine the efficacy of the APA. What you look at is to confirm that the parties have a meeting of the minds, whether to sell and whether to buy these specific assets of the entity that's before you for consideration. That's all you do relative to an APA. So recognizing the fact that that APA now was within the 90-day period, it still goes back to the trustee. Jared, doesn't change anything. So again, I think we keep going in circles about the fact that if you approve this, it doesn't extinguish or minimize or change the trustee's obligations. I would also respectfully submit that I don't know, and again, I did not prepare the APA. There were two separate parties for each of the applicant seller and applicant buyer. I suspect that's a typo, to tell you the truth. The November 1st, 2025 probably should have been November 1st, 2026, because as you indicated, generally we go at about 12 months. That said, that's not before you. You have an application in which two parties seemingly have appeared before you to say, I have the authority to sell, I have the authority to buy because I have the finances and I have the background and the operational experience. That's all you're determining. And then when it goes before the trustee, if they determine that the APA, the asset purchase agreement, was infirm, shouldn't have been entered into because of the 90-day stay applies to it, that's for them, the bankruptcy court to reconcile. It doesn't change anything. So again, the 120-day, and I think this is a very important, that's in which to submit the plan. Then thereafter, it goes through a process where the trustee evaluates everything. That just extends it. If we can submit a plan sooner than later, demonstrating the fact that there is a suitable buyer, one that's been found suitable by the TA, and that therefore, once the trustee approves it, we can immediately move into the compliance. That expedites things. We don't have to wait to that 120-day period. That's just the time in which you've got to submit the plan. We'd like to submit it sooner than later. In fact, we'd like to submit it again this week based on what we would like to see today's approval of the application and the ability for Pete Glow to move forward with the bankruptcy trustee and state, I am suitable to buy this. And if you approve it, I then go back to the Taxicab Authority, demonstrate that you've approved this, and then meet the compliance standards. And part of the compliance would be that condition that we have to obtain the bankruptcy trustee's approval before proceeding.
Mr. Hardy, what's the injury or downside to your position? That is precisely what we did, which was to approve the transfer subject to bankruptcy. What's the downside?
So here's the
We're
reality.
recognizing the jurisdiction of the bankruptcy court, and we're saying any decision we're making is subject to the condition preceding of a bankruptcy court approval.
Because what you're doing is you're saying the transfer is going to be effective, right? You can't, it'll be effective if you guys approve this one. And what you're doing is doing exactly what, as Rushton said previously, is she's asking you to put your thumb on the scale. And say, hey, look, this is somebody we like. This is somebody we're good with, right? And bankruptcy court hasn't asked you to do that. The reality is that there's going to be multiple, it has the potential to be, as you know, multiple bidders for this particular deal in order to get, and if you're putting the finger on the scale, and that's what she wants. She wants you to give you an answer today so she can run to court, as she indicated, run to the court this week and say, we have a plan with a ready bidder. So don't go out to the bidding process. Don't do anything else. And so where she wants you to do is put your finger on that scale in order to try to effectuate what's going to happen with this asset.
But hasn't that happened? Hasn't that happened with privileged licenses in Nevada?
Again, what they normally do they don't put their finger on the scale. They say this is an individual who is an approved buyer. Again, I go back to my original deal. Is he or can he be an approved buyer? Yes. And we have the jurisdiction to determine that he is an approved buyer. Now, whether he is approved buyer under the contract and the efficiency of the contract, there's some problems with that I won't, I mean, we can articulate because she brought that up, was you do have the ability to look at contracts and to look at them. You will not approve a sale. And I know this because we've been through multiple applications with multiple different agencies where they look at the contract and they say, hey, this term cannot be in the contract. Can you guys go amend this contract in order to bring it back to us? Because that's a term that would be contrary to this rule or this reg or anything like that. So to say that you have no input or you are unable to provide input on a particular contract based upon regulations or changes or things that may be improper, I think is a misnomer, first of all. And not only that, but you're going to be acting on a contract that is expired, that effectuated a transfer, again, based upon the history of this case. We file a lawsuit saying that there's mismanagement. We then go to a hearing on that. We go to hearing on that issue. And the judge says, I'm very interested in this particular issue. I think there's smoke. I don't know whether there's fire. So I'm going to stop a sale and we're going to have an evidentiary hearing on this. Okay. And then as soon as they realize there's about to be an evidentiary hearing on this, two companies file bankruptcy. And so all of that, if that doesn't call into question what was going on and all that, and now you put your finger on saying, well, we like the sale, let that process play out in the bankruptcy court. Don't put your finger on the scale yet and say we're going to help make calls in bankruptcy. See, we're going to allow the bankruptcy court. We retain jurisdiction, and you need to come back to us for any approved sale. When you provide and you identify one, we will then go ahead and do that because this license will be transferred without us. But we are not going to say who is or is not or should not be the bidders in this particular campaign.
I think we know your.
Yes, sir.
I do want to say it was brilliant to use Jerry's jurisdiction argument back against him.
Pardon?
She used your jurisdiction argument back against you, and I thought that was brilliant.
I was liking my chances.
It's getting bigger. Any questions, or are we ready to bring it back for? Any questions? Questions? Of them.
Yeah,
Any questions
I
amongst
had a
ourselves?
question for Mr. Hardy. I'm not sure I still.
You haven't made your mind up?
No, I had a question for Mr. Hardy, but I'm not sure I still have it in my head.
Oh, okay.
Yeah, I'll ask you one question. How does the bankruptcy assess potential buyers without knowing their suitability?
So the same way that you would. In order to be able, when the bankruptcy court does its due diligence, multiple bidders will submit bids in, and they'll identify their background, their history, and because I'm under the confidentiality agreements relative to the court, I can't describe the intricacies of those particular agreements. Only to say that there have been other agreements that were considered, okay? And that those other agreements could now go forward to the bankruptcy trustee. And if those agreements from those individuals are similar, the individuals there are similar to Mr. Balaban, who also own CAD companies here in town, they may also be suitable, right? Or you can put in there and say, hey, we own CAD companies nationwide. Here's our financials. We think we're an accredited bidder. Let us go forward. So the bankruptcy court will vet out to somebody that it's going to have the most likelihood of success before it ever comes back to you guys. And then you'll be able to look and say, based upon our criteria, we agree with the bankruptcy court that this is or is not a suitable buyer.
Sorry, I meant suitable to the board.
And you don't know because I can't tell you who all the other buyers are. And I, unfortunately, I can't do that.
So if the bankruptcy court picks a winner, let's say we're gonna go with this deal, and it comes in front of the board and board says no, for whatever reasons, we're not approving the sale, then
Next in line bidder would generally come forward. Yep.
Say that again.
The next in line bidder would generally come forward.
Right. And that's happened in
Correct.
particular.
Okay.
I'm aware of some banks transfer to other people who are running banks.
Yep. Especially back after the 2008 issues. Yep.
Well, I do think we're putting our finger on the scale, and I do think that the application and the I don't know if the agency has or the board has ever attested to someone's suitability before. I think the application is to approve the sale, and I think that's without getting the
To
jurisdiction.
approve the transfer of the certificate and the medallions, because we don't approve the sale doc.
Okay, well, okay. So I think that's premature and based on an agreement that whether or not case law supports it, I would be hard pressed to go against bankruptcy court and say, we're going to approve a contract that was within the 90 days and is now being, I don't want to use the word jurisdiction, being reviewed or overseen by, we're going to take action anyway. I feel no need to flex our jurisdiction for principled reasons.
Well, I don't know if I feel like we're flexing. I think we have to understand that that's what this board is designed for, to make tough decisions. And this is a tough one. They both presented very great, compelling arguments that I understand what the gentleman has said in terms of, and I think, Mr. Chairman, you alluded to I think you said something to the effect that they've, in the past, some boards have used the easy way out. I don't know if it's the easy way out. To me, I think it's a common sense way to just wait and see what the bankruptcy court says. That to me, it kind of makes sense. Let's not step into someone else's jurisdiction. I don't know if it's a matter of us over exceeding ourselves over some other jurisdiction, but that's what this board was designed for. But I also appreciate the fact that Valdan it has come to the table ready. And I don't know if I feel comfortable with the fact that I want to wait to give somebody else time to get themselves ready. That's where my dilemma is in this decision here. I appreciate both of your arguments respectfully. And so, yeah, I'm kind of torn right now. Just flipping a coin in my head, and not that I want to disrespect either one of you and your expertise, because I'm just sitting there like, wow. But I just feel like this board here shouldn't feel like, well, I don't know if we have a jurisdiction. I don't know if we can say this. I don't know if we can say that. If that's the case, I don't think a board like this would have ever been designed. You have to make a tough decision sometimes. And if in fact it's the wrong decision, that's what you have legal counsel for. That's where I am.
I am not.
Anybody prepared to make a motion? Let everybody reflect from. Or would you be prepared to make a motion if somebody suggested what it might be?
Well, I'm not prepared.
Because the chair is not supposed to make motion.
I'm not prepared to transfer the CPC and the medallions. So if I make a motion, not that, and I want to make it very clear on the record, as having nothing to do with Mr. Balaban's suitability, but having to do with the fact that there are some that I don't want to step on a potential bankruptcy. I'd be happy to attest to Mr. Balaban's suitability, but I think it would be premature for the board to approve the transfer of CPCN and the medallions.
Well, Mr. Chair, are we weighing in the fact that, and is that facts that because the assets are under the bankruptcy's review right now, that can't be dealt with until they deal with it? But just giving them just giving Mr. Balaban the opportunity to continue to move forward in his application, because according to Ms. Rush, and I agree, they've met all the regulatory and statutory requirements. Why would we hold them up?
So.
Sounds like a motion.
So I think what you're saying is unless there's some reason not to grant the application, you would do so? Is that?
I would.
Yeah.
Yes.
Okay.
You're breathing real
Are
hard.
you-
panting
Yeah,
over
no,
here.
sorry.
What are you saying?
Is this because you
He's
want to
good.
talk or? you-
Yes, he's giving me I don't know if he's having heart
Is he
palpitations. I'm the one supposed to have heart
Kicking?
palpitations, not you.
So you want to weigh in?
I don't know. Again, Matt Feely, Deputy Attorney General, Counsel for the Board. For the record, I tend to agree with Chairman Decker that there's no reason to rush right now. Even considering the application, isn't part of the application that they have a contract in place? And as Ms. Rushton mentioned, a meeting of the minds.
So the statutory provisions do not require the submission of a contract for sale. We do that again as demonstration of the fact that the parties have a meeting of the minds that they intend to sell.
But do they? Because the meeting of the minds is between the buyer and the seller, whereas
Correct.
the seller is no longer one of the minds involved. The seller is now the bankruptcy court and the trustee. So it doesn't seem like there's a meeting of the minds between buyer and seller.
And the 90 days in particular makes it so that any transactions there have to be reviewed by the
Right.
bankruptcy court. And because the bankruptcy court fears that there's always going to be the potential for people to unjustly transfer assets. So it's going to go back and look to see whether that's a valid contract.
It looks like what's going on here.
So that we don't proceed with, I think, a false flag here. I respectfully disagree with Ms. Rushton, even though that there is not a criteria for submission of a contract. Agencies do not process hypothetical applications. That is a long-standing, there are some states that allow
No, sir.
agencies to process a hypothetical transaction, but to have jurisdiction, there has to be a real deal.
I agree. But in other agencies, we simply sign an attestation saying that the parties agree to submit this application. That's what I'm saying. Is that
Okay.
again,
That's like the PUC and the joint application
Yes.
requirement for.
so that is generally
But
it.
even the PUC requires under 329 that you have the contract for purchase and sale of the utility. So.
You really don't in this instance.
Pardon?
Your statutory and your regulatory.
Well, I'm just saying, they have a regulation that says you have to submit that, but,
So
so I think without a contract, it would be, I think that contract is part and parcel of the deal, because it shows that it is not
Yes,
hypothetical.
I agree with that.
Okay.
And it also shows that it's not a straw man transaction.
That's
That
correct.
it's a legitimate
Right.
one and that it's compensable. And so again, to Member Weekly's point, maybe the motion is that you have reviewed the application, you find that the application meets the statutory and regulatory standards, sans the contract, which is before the bankruptcy court to approve, and you find that Peak Glow and the Balabands are suitable. That's it. And then the condition is that if he is a successful bidder, we come back to complete the compliance items.
And my proposal would be that it be simply that he is an acceptable applicant, but that you're not making a decision on whether he is the only applicant. And
The only applicant.
Before you.
but you're saying that if the bankruptcy court were to put another suitable applicant, we could approve them as well, right? And so, you know, I have no problem if you want to say after your review, he's a suitable applicant. I think that the bankruptcy court doesn't even need that because they're going to come in, I have no doubt, and say, he's an existing certificated holder, he's got all kinds of stuff, and they're going to show plenty of evidence that he's likely an acceptable bidder, right? Just like there will likely be a number of other acceptable bidders as well. And that's going to be the question for the court, is to look at that point in time and say, do they want to, and what they do is they ratify, as you know, they'll ratify the existing contract or they'll decline the existing contract. And they can look at this and say, we think that existing contract should be ratified, or they're going to say, we've looked at the facts and circumstances of this, we find it was done under some improper motive, and then they can decline the contract. And then at that point in time, we can move forward. And that's what's going to be at issue in the underlying cases, those type of things, which is why I'm saying, if he's just simply asking, hey, am I a suitable bidder? And you want to put your finger on the scale and say that would probably be about as far as I think the motion should go.
Which is acceptable because you could have applicants that come before you that have criminal background issues, that have tax issues, that otherwise would not be deemed. So by deeming him suitable, it does signify, I guess, to the trustee that they may proceed with approving Mr. Balaban's bid if that's the one they believe is the highest.
But you're not putting your finger on the transaction to say whether it's a good transaction or a bad transaction. You're simply looking at Mr. Balaban to say, we think he is a suitable candidate, but he may not be the only suitable candidate.
I suddenly have a motion.
I was taking some notes.
As was I.
Okay, so, great.
Let me try and get this all in here. I move that we consider the application as meeting statutory requirements, that we deem Peak Glow as suitable as a potential buyer, and that we decline to approve pending disposition by the bankruptcy court.
Can I,
Yes.
what, is there a second?
Mr. Chair,
Is there a second?
Mr.
Yeah.
Question? Oh, question.
Yeah.
You don't hear what I hear on this end of it.
That's a blessing.
Sorry.
I just want to make sure before I respond, because you're,
Too hyped up.
what's your thought? No, it's okay. I appreciate your legal guidance, but based on what you've heard thus far, are we on the right track in terms of this motion?
Again, I'm not, there's any.
No, I
deciding
know
factor
you're
here.
not,
Again,
but
so
I
I'm simply
just wanna-
presenting my opinion.
Yes.
I don't know. I think even that, in my opinion, even that seems a step too far. I don't see any harm in continuing this. We haven't heard from the potential seller or the bankruptcy court. Those seem like two important parties in coming to this decision. I see no harm in pushing this out until we get some further guidance from the bankruptcy court, from the district court, from the seller, from any other party that's involved here that we just haven't heard from yet. It seems to, what's actually on the agenda for today? This is an application for authority to acquire the assets. So is the decision
Allow the
here?
PPCN to transfer in the,
Okay, so then this other ruling of just simply declaring suitability, is that even on?
well, that is a fact, that is a finding we either have to explicitly make or will be an implied finding of a motion to approve.
That
he's
does,
fit-
that
he's
doesn't,
fit,
that he's fit.
No,
That doesn't even seem to be
the
in dispute.
statutory standard is that the acquiring entity is fit, willing, and able. And that the individuals owning and controlling that entity are suitable,
Fit, willing, and able to acquire.
fit, willing, and able to perform the duties of a certificate holder.
And I would argue that in the event that my motion to decline the application is approved, that it would be
Yeah.
paramount to make clear that it was not due to the suitability, the applicant being fit, willing, and able.
Yeah, I don't think anybody in here is
But if it's-
questioning the suitability.
Well, but the bankruptcy court might, so I think, yeah, I'm trying to
So
include. it in
why,
the-
so why even, exactly, so why
If
even?
it's denied, then we have a period, statutory period in which we can't refile. So again, there's ramifications for denial.
Say that again on statutory period, what, under the bankruptcy?
No, sir, if you deny an application, we can't immediately refile.
Oh, yeah.
So that's what I'm saying. Yes, sir. That's why we're asking again for at least a kind of a middle ground determination that the application meets the statutory criteria as he's suitable.
Okay.
And that's as far as you go.
And in addition to that, our judicial right for judicial review starts as well. So it's
We're deciding.
How about if I amend, say, the app meets the statutory requirements, we deem Pete Close suitable as a potential buyer, and we will continue the matter to the outcome of.
Say that one more time.
The application meets the statutory requirements, deem that Pete Close is suitable as a potential buyer, and we are
Fit, willing, and able.
fit, willing, and able, and we are continuing the matter pending the outcome of bankruptcy disposition.
Is he fit, willing, and able?
Huh?
Is he fit, willing, and able?
We've reviewed the,
Are you saying because of the bankruptcy case?
He's under a stay from trying to acquire property
Well,
that is currently,
Fit, willing, and able is his character, his finances, his probity, and his acumen. Those are the four elements. He's met, in my view, he's more than adequately proven that. So, I mean, so I think I don't have, I'm just going to say he's fit, willing, and able far, the entity's fit, willing, and able far as I'm concerned. Individuals are all current owners of companies and therefore clearly suitable. I think that the aspect of this that I'm struggling with is whether the contract is one upon which we can rely because of the 90 days. I'm less worried about the first issue I raised, which is it forcible against the seller? Absent bankruptcy or any other issue, is it just contractually enforceable?
and that goes to my first element, which is that the app meets statutory requirements, which I would remove because could argue both ways
Yeah.
based on, as Mr. Hardy.
I'm going to make a suggestion to try to cut the Gordian knot. I'm going to suggest that we make a finding that Pettiglow is fit, willing, and able, that the individual owners and control persons are suitable, and continue the matter to a date certain. We'll talk about the date certain, to act on the final aspect of the application, which is to determine whether there's a transfer or not.
Do we want to specifically reference the pending bankruptcy?
So I was
Outcome?
going to say that I would continue it for 60 days, maybe, for somebody to come back and tell me that the contract does not have bankruptcy clause, or how I solve for that issue. And and I'm open to, but we don't, I don't want to belabor this. I'm not sure we can act not knowing whether whether we're dealing with a hypothetical transaction. And in all due respect to Mr. Balaban, he's in the middle of a mess. And so I just don't want to approve a transaction ultimately where the contract is not because of what the parties did, but what the Bankruptcy Act does. That's my concern. But I do want to send a very clear signal to the bankruptcy court that, but for the bankruptcy, this get approved.
And Chair, one of the things that we've had when we've talked
Well,
about 60
This seems to get a motion.
Yeah.
February or something where we say February, the TA meeting in February or something like that, just because sometimes when we just.
Yeah. I get
60 days.
number of days.
Yes, sir.
Thank you. So that's my kind of suggestion, to split the baby.
Okay. So
Because I do think we don't want any action today be mischaracterized in the bankruptcy court or in the district court as anything but a full-throated endorsement of the application, but for the complexities created by the bankruptcy case.
Okay, so let's try this. I move that the board deems Pete Glow fit, willing, and able, and suitable as a potential buyer. And that we continue the matter to the regularly scheduled February Taxicab Authority meeting to hear about contract and status of the bankruptcy case.
Is there a second?
Second.
We don't usually allow people to comment when we have a motion and a second, so.
We're just saying that we think that it should be important that we keep you updated regardless. Is that if there's action in between now and February, that we notify the administrator.
Oh,
We can provide we can jointly provide a report or something along those lines, like a
So
joint.
they know.
Ms. Flynn,
Yes.
you keep the administrator. I'm not going to force you to make a joint one because you might not want to agree with.
We'll try to work.
We actually work on a lot of these.
Mr. Balaban may say, no, you can't say that. We have a motion, the second. Is there further discussion?
No.
Call for the question. All those in favor signify by saying aye.
Aye.
Thank you very much for your consideration. Thank you.
Active discussion. We need a break, or people ready to push forward?
Yes.
Break. Okay, we're going to take it is 11:23. We're going to take an exactly 7-minute break.